What happens when a tenant breaks a lease early? Early lease terminations have become increasingly common as work patterns shift, housing costs fluctuate, and mobility becomes a defining feature of modern renting. For landlords and tenants alike, breaking a lease early can feel confusing and contentious, particularly when legal responsibilities are not clearly understood. In Florida rental markets such as Pinellas County, where demand remains strong but affordability pressures persist, knowing what happens next is essential for protecting financial interests on both sides. Why tenants break leases before the end date. Tenants may end a lease early for a range of practical reasons. Job relocations, changes in household income, health concerns, or family obligations often prompt sudden moves. In Pinellas County, an influx of new residents combined with rising rents has also led some tenants to seek alternative housing options mid-lease. While these reasons may be understandable, a lease is a binding legal agreement. Unless specific legal exceptions apply, early termination typically triggers financial and procedural consequences. The legal and financial impact on tenants. When a tenant breaks a lease early, they are generally responsible for rent until one of the following occurs. The lease term ends, a new tenant takes possession of the unit, or the landlord agrees in writing to terminate the lease. Florida law requires landlords to make reasonable efforts to re-rent the property, a process known as mitigation. This means a landlord cannot intentionally leave a unit vacant while continuing to charge rent. However, until a replacement tenant is secured, the original tenant may remain financially liable. Additional costs may include advertising expenses, administrative fees, or unpaid utilities, provided these charges are permitted by the lease agreement. When breaking a lease may be legally justified. Certain circumstances allow tenants to terminate a lease early without standard penalties. These situations typically include active military deployment under federal law, documented domestic violence with proper notice, or rental conditions that violate habitability standards and remain uncorrected after notice. Even in these cases, tenants must follow legal procedures and provide appropriate documentation. Informal agreements or verbal understandings rarely hold up in disputes. What landlords are allowed to do. Landlords may apply a tenant security deposit toward unpaid rent or damages beyond normal wear and tear. Florida law requires landlords to provide written notice and itemized deductions within a specified timeframe. What landlords cannot do is charge excessive penalties unrelated to actual losses, refuse to attempt re-renting the unit, or withhold deposits without documentation. Consistency and record keeping are critical, particularly in a market where tenant turnover remains steady. How early lease breaks affect the rental market. In Pinellas County, early lease terminations can create short-term vacancies, but also present opportunities for repricing units in a competitive market. For tenants, an early termination handled responsibly is less likely to damage rental history. For landlords, clear lease language and prompt action often minimize financial disruption. As rental demand remains strong across much of the county, early lease breaks are increasingly managed as logistical challenges rather than prolonged disputes. Conclusion. Breaking a lease early is rarely without consequences, but it does not have to result in conflict. Understanding the legal framework, documenting every step, and communicating clearly can protect both landlords and tenants from unnecessary financial loss. In evolving rental markets like Pinellas County, professionalism and clarity remain the most effective tools for navigating early lease terminations.